Good morning. It appears both counsel are now in our virtual courtroom. Mr. Cuny, you may proceed.
Good morning, Your Honors. May it please the court. Ben Cuny, I represent Quantel Thompson, who is appealing his sexual battery convictions and life sentence based on a number of factors that we believe gave rise to an unfair trial, notwithstanding that Mr. Thompson did make inculpatory pretrial statements. I would like to reserve 4 minutes for rebuttal for this argument.
Very good.
The court is familiar with the facts of this case that involve 3 parts: allegations of sexual battery in Florida, allegations of sexual battery in Texas, and then allegations of sexual battery moved back to Florida. We have challenged a number of issues dealing with the child hearsay admissibility.
Mr. Cuny,
Texas conduct was admitted as Williams' rule.
Mr. Cuny,
Insufficient evidence.
Yes, Mr. Cuny, it appears you froze for a moment there. I'm not sure if you're coming up with any technical glitches, but I'll try and let you know if it happens again.
Thank you. I do apologize. I'm using a circuit judge's chambers for argument. I'm in a criminal trial now, and Judge De La O has graciously allowed me to do the oral argument from his chambers, and I've had good Wi-Fi so far, so I do apologize.
Very good.
The third issue, which is the first issue I'm going to address, deals with the sufficiency of the evidence to support the count 3 allegation. That's based on proof of age. We also raise, for preservation purposes, the request for this court to certify the 6-juror versus 12-juror question based on Supreme Court precedent. And we've challenged the prosecution's closing argument. And there is an issue that we preserved in the brief for sentencing computation. Moving to point 3, which our brief suggests was the result of much of the evidence that came into the case generally prejudicial and not necessarily directed toward the charging document. In count 3, Mr. Thompson was charged with lewd and lascivious on a child younger than 16 on a specific date range, December 13th through 31, 2020, notwithstanding the conceded evidence that the victim, the child, was 16 years old on December 13th. The defense raised this issue not as a variance between allegata and probata, but as a failure to prove the essential element of 16 years of age under. At her birth date, she was 16 and not a victim for purposes of this charging document. We liken this case to a case cited by the state, a second DCA case, State versus Sanders, decided relatively recently. And that case deals with, although a different situation, that was a motion to dismiss an information, and the court held that it was proper for the state to amend the information. Here, there was no request to amend during the course of the trial, and the case was tried on the allegation that the child was 16 years of age, when in fact the proof was clear. Allegation that she was less than 16 years of age, and the proof was undisputed. She was 16. Under the Sanders case, while a variance may not give rise to reversible error, where the failure of proof deals with a charged element of the offense, that is not subject to the variance rule of notice and an opportunity to respond. Here, the case was tried on the allegations and the proof, and the state presented a case that resulted in a complete failure of evidence. We asked the court to conclude that count 3 should be vacated and the case remanded for discharge, or alternatively, a lesser offense that does not involve the victim's age.
Mr.
We
Cuny,
note-
am I recalling correctly that there are some cases that require a showing of prejudice by the defendant in order to get relief in this type of situation?
Your Honor, you are correct that the Sanders decision, as well as the Sanchez decision that we cite in the briefs, talk about a variance, and a variance does require proof of prejudice. What is the prejudice to the defense? That's different from the language in Sanders that says and I will note, in the rare case where the evidentiary insufficiency deals with an element of the offense, then that's a reversible error, not based on the prejudice, because there is a wholesale failure to satisfy the evidentiary elements beyond a reasonable doubt. That's why this case is not argued as a variance, but rather a lack of proof. The jury did. Yes, Your Honor.
So, Mr. Cuny, your argument would effectively be the same regardless of how it was charged, is what you're saying, correct? It's really an error independent of the charging document. It's a failure of proof. Or does your argument necessarily depend on how it's been charged?
Mr. Cuny, if you can hear me, you may be frozen again.
Only time frame for this violation was essentially the 15 days in December. And during those
Mr. Cuny, you're
15
frozen.
days.
Mr. Cuny?
So the state, Your
it
Honor, I
looks
think
like-
that I've been interrupted.
No, you're freezing intermittently, unless one of the other judges is not having the
By
problem.
the internet?
No, it's the same for me. There's an
Yeah.
intermittent freezing that I was hoping it would blow over, but it seems to be getting a little bit more prominent as we go.
I apologize, Your Honors. I'm going to try to call in on the phone. I do not know what happened, and I will let the judge know his chamber's internet was a little bit problematic, and I'm very apologetic. I had tested this before and had no problems with it whatsoever.
No problem. It does happen. Just when you do make the phone connection, go ahead and start your answer to Judge Rossin-Yoakum's question once again. I did get a message from the rest of the court saying if you turn off your camera, that may alleviate the problem. That may be sucking up more bandwidth than is helpful.
Are you able to hear me now, Your Honors?
Yes,
Yes, we can hear you.
Let me try to do it this way rather than calling. And again, my abject apologies. Your Honor asked the question about a charge, whether this is a charge issue or an evidence issue. And our position is set out in the briefs, is that the lack of proof is an evidence issue. The element of the offense is age. And here the only time frame for this charge, the 15 days in December, is clear, undisputed, that the victim did not satisfy the age requirement. And
Okay. And so what I was asking was, and not, even if it had charged, say, on or about those dates, would you still be making the same argument based on a failure of proof, or does your argument even though made in terms of the sufficiency of the evidence necessarily implicate the charging information?
The latter, Your Honor. It does derive from the charging information. So hypothetically, if the state had said, Your Honor, we want to amend the information to put a year's worth of activity, subject to due process issues, if there was evidence that in that year's worth of activity, the victim was under 16 years of age, that would satisfy the charged crime. Here, the crime was specifically alleged to be a particular time for reasons known to the prosecution and was tried on that. This issue was objected to during the course of the judgment of acquittal and later post-verdict motions. So all the parties knew that age was an essential element, and the state failed in that proof. I note that the jury did find in the verdict age of under 16. We've alleged that the compilation of other errors in this case, including the child hearsay, which we believe the trial judge did not make the required findings, and the Williams rule, so led to such an enormous situation of abuse for a long period of time that the jury had no option but to find him, the client, to have committed sexual battery on his daughter, something that he did admit in part, but certainly not as to the time frame when she was 16 years old. We believe that the child hearsay, unnecessary in this case and not subject to the Townsend analysis in the judge's order allowing the hearsay, coupled with the Williams rule of the activity in Texas, noting in Texas she plainly was under the age of 16, although not charged. The trial judge made no determination in allowing, and this is point 2, allowing the Williams rule to be utilized despite not proving by clear and convincing evidence the allegations that occurred in Texas. The enormity of the prejudice in this case is so great as to essentially have spun over into the count 3 conviction despite there being insufficient evidence. We've also argued that the closing argument in point 5 by the prosecutor, essentially vouching for the credibility of the state's case and the victim, using the, I would say, close to prohibited phrases, I think, we know, suggested that the prosecution knew the outcome of this case, was invested in the outcome of this case, and was there prosecuting the case to protect my victim, his words. We believe that based on the case law that we've cited, personal veracity vouching, the U.S. versus Weatherspoon case, as well as suggesting sympathy for the victim when the prosecutor said, I think she was traumatized. Trauma not being one of the elements of this case suggested that the prosecutor believed the jury should convict based on sympathy for the victim. We believe that under the Johns case I've cited, that is improper and added to the prejudice in this case that we argue is unfair prejudice. And although I have raised this point at the introduction, the issue of a jury of 12 versus a jury of 6 is an issue that I request, the defendant requests, be certified to the Florida Supreme Court, given the decision of Ramos versus Louisiana, which implicitly overruled Williams versus Florida, allowing 6-person juries in cases like this. We do recognize that State versus Hogan says if death is not a possible penalty, but we do note that the importance of this issue is made all the more relevant by the legislative enactment effective October 2023, where child sexual battery, the offenses of conviction here, are subject to the death penalty. So we ask this court to certify that question, and for the other points not raised, I stand on the brief for those purposes.
Very good. Thank you very much, Mr. Cuny. You have your 4 minutes of rebuttal time. And Ms. Reina Pimiento, you may proceed.
Thank you, Your Honor. Good morning. Before addressing the issues raised by Mr. Cuny here, I would like to talk a little bit the type of case that you have here today. So you have a case in which a father is accused of sexually molesting his daughter, for a long period of time. Not only he's accused, there is multiple evidence where he accepts to this molestation. And this molestation, according to his words, started in 2010 and lasted until 2020. For 10 years, he molested the child. That's the type of case that you have here. When Mr. Cuny talks about prejudice with certain evidence that was admitted during trial, certainly that was not prejudicial. That evidence was not even necessary in this case for the jury to reach the decision that it reached. So with that in mind, I will address point 3 of Mr. Cuny initial brief, who deals with the lead and lascivious molestation and the problem with the date range and the charging offense. Whether you have a variance or you have an argument of lack of proof in this case, the result is exactly the same, Your Honors. As I mentioned before, if you are talking about failure of proof, the father accepted in multiple occasions that he molested his child since 2010. She turned 16 years old in 2020, December of 2020. So you have 10 years of multiple molestations. And those molestations involve not only touching, involves oral sex that he accepts in this case. So there is no lack of proof, Your Honor. What you have maybe is a variance in an indictment, a problem and in information, a problem with the dates that the state had in the information. But that was, as the trial court found, it was a mistake because
one question on that issue. The Sanders case did have an effort or an amendment to the information that was requested at trial. We did not have that here, but Sanders also has some language that seems broader than simply a question of amendment. So I'd like you to address, is the language in Sanders that goes outside of the context of the amendment, is that dicta that is not necessarily binding on us?
Your Honor, certainly the facts in Sanders and the general setting up in Sanders is different from the case here. But Sanders recognized the general rule that variances in an indictment are not fatal for a prosecution case when the state is able to prove all the elements of the offense occur before the filing of the information. And that's what you have here. Now, Sanders said there are certain situations in which the date range that is in the indictment is fundamental. It goes to the nature and the legal nature of the offense. So that in that part, the way that you use the information is essential to proving the charge.
Well, let me interrupt you on that. Is there a different crime for sex by someone over 18 with someone who is 16 or older versus someone who is under 16 over 12, for example?
There is a difference in sentencing, yes.
Is it difference in sentencing, or are they different essential elements to a crime?
I don't think there is, I mean, that in that case, it would be lewd and lascivious molestation over a person over 12 years old, but under 18 years old. So that will be the crime in this case that could have fit within that specific time range.
Well, then, and I understand that's what the evidence showed, but the evidence is inconsistent, at least to a degree, with the dates alleged. So I go back to the question of, is the allegation of sex with someone age 16 years or older a different crime than one that would allege sex with a minor 12 years, between 12 years and 15 years, 364 days?
Your Honor, I do not have the statute here, so I couldn't specifically tell you what the statute says about the difference in the crime. What I can tell you is that the crime that was charged here was a lewd and lascivious molestation of a child under 16 years old, independently of the date range that was included in the information. And that specific offense was vastly proved in this case, not just by the testimony of the victim, by the acceptance or the statements of the father of the victim, in this case, the appellant. So I believe there will be a difference between the sentence. I don't know if the charge will necessarily be different. And I apologize, Your Honor, I don't have an answer to that specific question. But I can tell you that when you look at the information, it was clearly a mistake, because the day that they selected in the information is the day when she turned 16 years old. So definitely it was a mistake here, as it was recognized by the trial court. But the crime.
So what your argument seems to be, the assertion in the information, or the allegation in the information, was that even though there's a date specified, that the allegation itself is a child under 16 years of age.
Exactly, Your Honor. That's the charge that was.
So there's an inconsistency between the dates alleged of the crime and the actual allegation of fact.
Exactly, and that's why this is a problem with a variance in the information, a mistake in the information, not a failure of proof in this case. Clearly, he abused this child before she was 16 years old. And in fact, I mean, she opened to her mother about what was happening when she turned 16 years old. After she turned 16 years old, nothing happened, because that's when the investigation started in this case. So it will not make sense to have charge. I cannot tell you exactly what the state was looking exactly to charge. I could tell you that charging a crime in those specific dates will not have made sense, because at that point she had already, the investigation against her father had already started. So what you have here is a problem with a variance, that it was not fatal to the prosecution because the charge was plenty proof beyond a reasonable doubt in this case. Now, Your Honor, regarding the improper comments in this case, this prosecutor comments, there are two types of comments that Mr. Kinney raised in his initial brief. The ones are related to statements of the prosecutor talking about my victim, and that he said vouch in some way for the credibility of the victim. But when you look at those comments in the context of the comments, that was not the case. First, Your Honor, the state had 11 pages. You look at the transcript, they have 11 pages of closing arguments, and only one line where he talks about my victim. Now, when he said my victim, it was in the context of explaining some of the elements of the offense of battery, and why battery as a lesser included offense did not apply in this case. When he said my victim, the defense objected. The trial court asked the prosecutor to correct its statements. The prosecutor corrected its statements, and the defense did not move for a mistrial in this case. So this was not preserved, but also it was innocuous. It was one line in 11 pages of transcripts in this case. Now, when he corrected, he explained that all that he wanted to say is that the victim was underage. In no way he put or vouched for the credibility of the testimony of the victim in this case. The other comment that he mentioned have to do with talking about the victim being traumatized. Once again, Your Honor, you have to look at those comments in the context of the case. What happened here is that the defense was arguing that a traumatized victim should, in the closing arguments, that a traumatized victim should remember all the facts that happened in this case, that inconsistencies that she had in her testimony were not credible, because a victim that is traumatized should remember that. when the prosecutor came in the rebuttal arguments and he said, look, the defense mentioned that she was traumatized. Yes, she was traumatized, and that's what she doesn't want to talk about it. Once again, there was an objection. Once again, he rephrased, and they did not move for a mistrial. That's the way that you preserve that issue here. But it was definitely an invited response to the defense that was the closing arguments of the defense. In no point those were improper comments, Your Honor. Based on the case law that allowed those invited responses, that's what the prosecutor was doing in this case. Now, Mr. Kinney also talks about the 12-person jury issue. I think this court, the Florida Supreme Court and the United States Supreme Court, is very clear in this precedent that in those cases in which the death penalty, even if you have a capital offense, a conviction for an offense that is a capital felony, if in those cases you cannot impose the death penalty, there is no need to have a 12-person jury. That is a settled issue. This court recently actually issued an opinion in which it pretty much agree with that statement. And there is no reason to certify a question that had already been decided by the Florida Supreme Court, and that is clearly the United States court is not interested in dealing with or changing its decision in Williams versus State versus Florida, in which they rule that the 6-person jury is appropriate in these type of cases. So there is no reason to certify this question, Your Honor. With respect to the child hearsay and the Williams rule evidence, Your Honor, those issues were not properly preserved in this case. Moreover, with respect to the child hearsay, the trial court make all the findings that the statutes and the case law require in this case. The only issue raised in the brief was some related to the contradictions that the victim has in their statements. But even if it was an error admitting those statements, those errors were not prejudicial to the appellant. In fact, those errors could have helped appellant because that was the only evidence that the defense could grasp to argue that this crime may not have occurred or that the victim had a motive to lie. In fact, those little contradictions that, as the trial court found, were minor, they actually provide the defense some way of defense strategy in this case. You cannot argue those were prejudicial. And that is, Your Honor, unless you have another question for me, I will rely on the arguments I presented in my initial brief. But I will say that the evidence in this case is so overwhelming, coming directly from appellant, that there was no reason that even if you have an error in this case, that error could have influenced in any way the decision of the jury to acquit versus convict the appellant in this case. Thank you.
Very good. Thank you very much, counsel. Mr. Cuny, you have your 4 minutes of rebuttal time.
Thank you, Your Honors. I'm going to just stay on audio to avoid any transmission issues.
Very good.
Focusing first on the date range issue. There are 2 points that are most pressing on this. First, there was never the suggestion at trial that the charge was a mistake, nor was there any effort on the part of the prosecutor to correct something that on appeal is considered a mistake. But more fundamentally, because the Sanders case makes clear in its language that where a date-related inadequacy touches to the, quote, nature or legal existence of the offense, end quote, which is precisely what is at issue here with an essential element. We have no idea how the jury considered the Texas conduct that may give rise to a Williams rule usage, but not usage as evidence of the crime charged. It is
Mr. Cuny,
conceivable.
so talking about
Yes,
Sanders, the court quoted from Horton versus Mayo. And the language that they quoted seems to be helpful to the state in this case. So what are we to make of that?
Your Honor, Sanders tries to walk the divide between date ranges that simply deal with factual evidence and dates that are essential to the charge of conviction or charge of prosecution. And that's why, in citing to Horton v. Mayo, the Florida Supreme Court en banc case, the court says, and I'm at pinpoint page of Sanders.
It's on 962.
962, I'm sorry, 962. In the blocked quote, the last phrase, except in those rare cases not here in point, where the exact time enters into the nature or legal existence of the offense. That's the crystallized issue raised in point 3. The legal existence of this L&L charge is proof of age, which was completely unfounded in this case and could have been determined by the jury based on uncharged conduct, Texas crimes that were not chargeable in Florida. So
But
we
there's
asked
also,
the court
you
to find.
You do acknowledge, though, that the amended information and the original information both allege the crime as taking place on a child under the age of 16.
No doubt, Your Honor, that is the charge. And that's important because the court asked, well, what's the alternative? The alternative, as pointed out in the brief, is the lesser included offense of battery. That's a crime that is not age dependent and has no element of age. That would be, if the court deems appropriate, the offense for reduction of this charge, although we believe that the proper remedy is to simply vacate for lack of evidence. The state has raised the issue of the improper comments. As the brief points out, these were sufficiently preserved and the comments went to the very core of this case. Prosecutor as protector of victim, which is not an element, a theme, or a motive for prosecution. And certainly there's no invited response because the defense, although arguing in ways of believability, did not put the relationship between issue. Also, Your Honors, with regard to
Mr. Cuny, let me just
12-person jury issue.
Mr. Cuny, let me let you know you have come to the end of your time. Take 15 seconds to conclude, please.
Yes, Your Honor. As the courts are aware, law is evolving, and the Hogan case was 1984. The Supreme Court in 2020 and again in 2022 has questioned 12-person versus 6-person juries. We ask the court to reverse and remand for the reasons stated in the briefs. Thank you, Your Honors.
Very good. Thank you both. Very well presented case. You can exit the courtroom if you hit on the button that either says leave or exit. You will be released from the courtroom. And thank you very much.
Thank you, Your Honor.
You're welcome. The next case is Kozel versus Kozel.